Today in Brunswick, Georgia, the murder trial for the three men accused of killing Ahmaud Arbery began with the defense presenting its case by calling their first witness, Travis McMichael, the one who pulled the trigger. He spent several hours on the stand today under direct examination. The prosecution will proceed with cross-examination tomorrow. I've got my legal expert on deck to help us talk through the latest in this trial, former president of the National Bar Association, C.K. Hoffler. Always great having you on, counselor. Let's get right to it, shall we? Kevin Goff, the attorney representing William Bryan, reserved his opening statements until after the prosecution rested their case. So instead of giving it at the start of trial, like the other two defense lawyers representing the McMichaels, he made a decision to do it after the prosecution rested. Now, he tried to point out and separate the actions of his clients from those of his co-defendants. Now, I've asked whether this was a smart move to save addressing the jurors until after the prosecution presented all of their evidence, but that was before we saw just how damning that evidence was. So I have to ask again, was this a smart move to hold off on addressing the jurors until now?
Yodit, I think that it was a fairly decent strategic move for this reason. Kevin Goff is trying to make sure, as much as possible, he wants to make sure he can separate the actions of his client with the actions of the McMichaels, with the hope that by separating them out, if the jury in any way, shape, or form convicts the McMichaels, that they will see his actions as separate, as lesser, as not as bad. I think that was the strategy. What we know as spectators and as the media that have been in the courtroom is that his questioning, his motions, all that he's done in the course of this trial has been the most obstructive that I've seen of any defense counsel in many years. So I think that his strategy was to separate them, to make him look like he's not as bad as them. But by the same token, I believe they're all lumped together.
So, CK, why not ask for a severed trial then?
Well, I think, he probably should have asked to sever the trial early on. I do think that he probably made a strategic move because initially they probably thought, one, they were never going to get indicted, but two, once they got counsel, that this case there wasn't a chance that they would get convicted. I think that they felt very comfortable and very entitled, if you will, that the community, not anyone in that community would convict them for what they feel strongly were acts of self-defense. I believe that they actually believe that. There's not evidence to support it, not by and large, not beyond a reasonable doubt, but they actually believe that or want to believe that. And I think the lawyer for Bryan is drinking that Kool-Aid and just felt, look, it's better if they're all there together in some respects and he can separate himself out, just try it at one time. And they may have actually moved to sever the case, and maybe that motion was denied. I've not heard of any motion to sever, so I'm not certain if they did it, and if so, why it wasn't public. But I've not heard of any motion to sever, but that's what he probably should have done, frankly.
All right, so let's get to the first witness the defense called. That was Travis McMichael. Not sure if he took cues from Kyle Rittenhouse, but were you surprised that he took the stand?
I was pretty surprised that he took the stand. I thought that Bryan would take the stand. Mr. Bryan would take the stand. But I thought it was a very, very difficult and calculated decision for him to take the stand. He is, after all, the person that shot and killed, technically, Ahmaud Arbery. So for him to take the stand, for him to be the first witness out, you're putting a lot of eggs in that basket. And based on his testimony, well, I think he was exceptionally well coached. And as you saw, the defense lawyer led him down a path. I was just shocked that there were not more objections on leading. I mean, he was leading his witness, testifying for him, all of those things. I guess the Prosecution felt there's no need in objecting, let them go and do what they're going to do. But I think it was a calculated risk. I think it was a gamble. And I think he's going to have his head handed to him on a platter tomorrow. The prosecutor has all night, and she probably will take literally all night to prepare for the rest of the cross-examination. She very wisely started the cross-examination, hit him with a few things just to begin, set the traps. But tomorrow, I hope what she does is takes every statement, because they have real-time court reporting, every statement, and juxtaposes that statement with the visual evidence. Because even without seeing the video right there when he was speaking, I could tell there were tons of inconsistencies. First of all, what he was saying just didn't make any kind of sense. Didn't make common sense, didn't make silly sense, didn't make simple sense, didn't make any kind of sense. And what I was thinking consistently as he was talking about his options, what he did, how he did all these things, I was thinking of how Ahmaud Arbery must have felt. That is what really struck me throughout, how Ahmaud Arbery must have felt like he was trapped, how he was fighting for his life. And when Travis broke down and cried, if you will, and he cried because he said at that moment when he shot Ahmaud Arbery, he was thinking of his son. He wasn't thinking of the man that he shot. He wasn't thinking of the man that he killed. He wasn't thinking of all the danger he had done. He thought of his son, and the callous nature of him to say that in the courtroom with Ahmaud Arbery's mother sitting in the back. Who was thinking about her child? Who was thinking about her son? I just think this was a calculated risk.
Well, before talking about the day of the shooting, the defense spent time talking about Travis McMichael's background, including his Coast Guard training. Let's take a listen to that.
In your experience, can pointing a gun at somebody de-escalate a situation?
Yes.
How so?
Well, if pull a gun on someone, there's time they've realized that this is, if it's threat or if you don't know what's going on in a situation and you pull a weapon on someone, from what I've learned in my training, that usually that calls people to back off or to realize what's happening, compel compliance.
CK, we heard similar testimony from Kyle Rittenhouse where he thought pointing a gun at someone would get them to retreat. Will his Coast Guard experience and his handling of weapons, so to speak, help justify his actions with the jury?
I think he's certainly hoping so. I think it's a double-edged sword, though. The reason why he's hoping it will help is because it sets a stage for him being somewhat of an expert. A fact expert, yes, a defendant, but an expert, where he talks about all of his training, because all of that training, he's going to argue in the end, kicked in, and that's why he did what he did. The double-edged sword to me is that all of that training should have kicked in to tell him, don't do this. But it didn't, because he was not acting as a reasonable man.